Here's something I've noticed about partnerships. They almost always begin at the highest point of trust and the lowest point of clarity. And that's exactly what makes them dangerous. Because most partnerships don't break at the beginning, they break later. They break when somebody wants out, or when the business finally starts making real money, or when one person feels like they're carrying all the weight. They break when death, divorce, debt, or disagreement walks into the room. And by then, the question is no longer, do we trust each other? The question is, what did we actually agree to? That's what we're talking about today. Because at the end of the day, a partnership is a contract you write by imagining the future you hope never comes. Welcome to Law, Land, and Capital, where we talk about the legal, business, real estate, and capital issues that serious people need to understand before things go sideways. Today, we're talking about partnerships. And I mean that broadly. Business partners, real estate partners, family ventures, professional practices, two friends starting a company. Maybe one person brings the money and the other brings the skill. Maybe somebody brings the deal or the land or the relationships. At the beginning, it always feels simple. Everybody's excited, everybody trusts each other, and everybody says the same version of the same thing. We'll figure it out. But here's the problem. We'll figure it out is not a partnership strategy. It's a risk. So today I want to give you a framework, not a form that you can download, not some generic checklist, a way of thinking. And if you remember nothing else from this episode, remember these three questions. How do we run it? How do we change it? And how do we end it? That's the partnership test. Everything else we cover today fits inside those three questions. Of course, I'm a lawyer, so quick legal note before we get into it. This episode is a general education and commentary. It is not legal advice. Every situation is fact-specific, so if you need advice about your particular situation, speak with a lawyer licensed in your jurisdiction. All right, with that said, let's talk about partnerships. All right, so let me start with a story. It's not a client story, just a hypothetical, but it's one that plays out in real time all the time. Two brothers decide to start a construction company. We'll call them Marcus and Daniel. Marcus is the operator. He knows the crews, he knows the job sites, he knows the vendors. He knows how to talk to customers, and he knows how to solve problems when a job starts going sideways. Daniel is a different type of asset. He has a stable job, good credit, money in the bank, and he believes in his brother. So Daniel makes the offer. You know the business. I have the money. I'll put up the first $150,000, you run the company, and we'll split everything 50-50. At the beginning, it sounds perfect. They're brothers. They trust each other completely. Their families are excited. They're sitting around the kitchen table talking about the company name, the first truck, the logo, the website, the future. And nobody wants to ruin that moment by asking uncomfortable questions. What if this doesn't work? What if one of us wants out? What if one of us wants more control? What if the business needs more money down the road? What if one of us gets divorced? So they skip the hard conversation. They shake hands. Maybe they form an LLC. Maybe they open a bank account. Maybe they download some document off the internet. Maybe they don't do any of that. But in their minds, it's fine. They're family. They'll figure it out. And then something interesting happens. The business starts working. The company lands a big project. Revenue goes up. Suddenly, Marcus is working 70 hours a week, managing crews, chasing payments, dealing with customers, fixing mistakes, making decisions all day long. Meanwhile, Daniel is still at his full-time job. But now Daniel starts looking at the bank account and he starts asking questions. Why are you paying yourself that much? Why'd you buy that truck? Why'd you hire that guy? Why'd you sign that contract without asking me? So of course, Marcus gets frustrated. Because in Marcus's mind, Daniel isn't in the field. Daniel isn't dealing with the pressure. Daniel put in money once. But Marcus is building the business every single day. Daniel sees it completely differently. In Daniel's mind, his money created the opportunity in the first place. His credit helped launch the company. He took the first risk back when the business had nothing. And this right here is where partnership disputes become truly dangerous. Not when one person is obviously wrong, but when both people have a story that makes sense. Marcus says, I built this. Daniel says, I funded this. Marcus says, I should control the daily decisions. Daniel says, I own half. Who's right? That's the wrong question. The right question is, what did they agree to? And the honest answer is nobody knows because they never wrote it down. So here's the first big idea I want you to sit with. A partnership is not just a relationship, it's a structure. It's legal, it's financial, it's operational. People think they're choosing a person, and yes, the person matters, but trust matters, character matters, work ethic matters. But legally and financially, you're also choosing a set of rules. You're choosing rights, you're choosing duties, and you're choosing consequences. And here's the part most people miss. You always have a partnership agreement. Always. The only question is whether you're the one who wrote it. Because if you don't write the rules, the law fills in the blanks for you. Your state has default rules. In Texas, it's the Texas Business Organizations Code. Your entity documents have default provisions. Your operating agreement might say something you never fully understood. Or maybe your agreement is completely silent on the exact issue that now matters most. But silence doesn't mean there's no answer. Silence usually means somebody else already answered it for you. And it may not be the answer you would have chosen. That's why I think of the partnership agreement as the constitution of the business. It governs who has power, who has economic rights, who can make decisions, who can access information, who can bind the company, who can leave, who can be bought out, and what happens when the relationship changes. And relationships do change. Sometimes because the business fails, but just as often because the business succeeds. Success can create every bit as much of conflict as failure. When there's no money, people argue about survival. When there is money, people argue about entitlement. Who built the value? Who took the risk? Who deserves the control? Who deserves the distributions? Who sacrificed more? Surely you can see where this goes. That's why silence is never neutral. Every term you don't negotiate is still a decision. It's just a decision you allowed someone else to make for you. And that's really why the agreement matters. Not because paperwork is impressive, but because the agreement answers the hard questions before the hard moments arrive. Now, the master skill in partnership planning, and I do think of it as a skill, is learning to ask what if before you need the answer. What if one of us wants out? What if one of us dies? What if one of us gets divorced or stops working or wants to sell? What if we simply disagree and can't break the tie? And the list goes on. These are not negative questions. They are responsible questions. The real enemy here is optimism bias. Think about day one of any partnership. Everybody's friendly, everybody's aligned, everybody's excited. Nobody's angry yet. Nobody feels betrayed yet. Nobody's staring at the numbers thinking, I deserve more. And that is exactly why day one is the best possible time to make all of the rules. Because calm people make better rules than angry people. You agree now while everyone is rational on what the process will be later, when everyone might not be. That's not pessimism. That's respect. I like to think of a good partnership agreement like a fence between two neighbors. Putting up a fence doesn't mean that you hate your neighbor. It means both of you know exactly where the line is. And because the line is clear, the relationship is easier to protect. A good partnership agreement does the same thing. It creates boundaries, it creates process, it creates expectations. So when pressure comes, people aren't starting from emotion, they're starting from the rules. The best time to talk about conflict is before there is any. Because once the conflict starts, every vague sentence in your agreement becomes expensive. That's the what if lens. Negotiate the beginning as if you're planning the end. Okay, so let's make this practical. Before you enter any partnership, ask yourself 3 questions. How do we run it? How do we change it? How do we end it? That's the whole test. How do we run it covers rights, roles, responsibilities, money, control, daily operations, major decisions, access to information, and authority. How do we change it covers adding partners, removing partners, bringing in new capital, changing ownership, shifting responsibilities, and amending the agreement itself. And how do we end it covers exit, death, divorce, disability, deadlock, dissolution, buyout, valuation, and winding up. Now, here's what I've observed. Most people are perfectly comfortable with the first question. They'll happily talk about the business idea, the name, the profits. They'll loosely say things like, you handle the operations, I'll handle the money. But they avoid the second and third questions. How do we change it? How do we end it? Because those questions feel uncomfortable. And yet, those are usually the questions that matter the most later. A partnership that can't change becomes rigid. A partnership that can't end becomes a trap. So let's walk through the framework piece by piece. The first category is rights, roles, and responsibilities. It sounds technical, but it's really 4 simple questions. Who gets what? Who does what? Who controls what? And who's responsible for what? Let's go back to Marcus and Daniel. Daniel put in $150,000. Marcus runs the business. They agreed to 50-50 ownership. But stop and ask, what does 50-50 actually mean? Does it mean 50-50 profits, 50-50 votes, 50-50 control? What about 50-50 risk, 50-50 work, 50-50 personal guarantees? This is where people get into trouble because a lot of folks use equal ownership as a shortcut for fairness, and equal is not always fair. Don't assume 50-50 means fair. Equal ownership does not always mean equal work, equal risk, equal authority, or equal pressure. In some partnerships, 50-50 makes perfect sense. In others, it's a deadlock machine. If both partners have equal power and they disagree, who breaks the tie? If there's no answer to that question, the business can simply freeze. That's why governance matters. Who can hire and fire? Who can borrow money or sign a lease? Who can approve distributions? Take a salary, bring in new investors, sell company assets. You don't need to carry a 5-page list around in your head. You just need to understand the category. Authority needs rules because in the day-to-day life of a business, control is often more important than ownership. Someone might own 50% and still not be the right person to make the operational decisions every day. Someone else might own 20% and be the key operator that everything depends on. The same goes for contributions. One person might contribute capital, but no labor. Another might contribute labor, but no capital. Both are valuable, but they're not the same thing. So if one partner is the money and the other is the work, define what that actually means. Is the money a loan or a capital contribution? Does it get to be paid back first? Does it earn interest? Does the working partner get a salary or extra equity? What happens if the working partner stops working? And what happens if the money partner refuses to put in more? You get the idea. The agreement should define the economics, the authority, and the responsibilities before the pressure hits. And don't forget personal exposure. Because sometimes the most important question isn't how much do I own? It's what am I personally on the hook for? Did you sign the lease? Did you guarantee the loan? Did you guarantee the vendor account? Did you pledge collateral? Ownership is one thing, exposure is another. A good partnership agreement makes that distinction crystal clear. Now, let's zoom out and look at the life cycle of a partnership: creation, operation, and winding up. The beginning, the middle, and the end. Most people only ever focus on the beginning. They ask, what entity are we forming? Who owns what percentage? How much money are we putting in? What's the name? Those questions matter, but they're nowhere near enough. At creation, you should also be asking, what is each person actually contributing? What authority does each person have? What happens if the business needs more money? And critically, how do we value the business if somebody needs to be bought out? That valuation question is huge. And here's why. Most people wait until someone actually wants out before they ever discuss valuation. That's a mistake because Once someone wants out, valuation becomes personal. The person leaving wants the highest number, the person staying wants the number low. So choose your method before anyone knows who it will favor. Maybe that's an appraisal process. Maybe it's a formula. Maybe it's based on revenue or cash flow or book value. The right method depends on the business. The point is simple. Pick the process before there is ever a fight. Then comes operation. How the business actually runs day to day. What decisions can one person make alone, and what requires approval? What happens if the partner's deadlocked? How do profits get distributed? And when do you hold back reserves? Can you bring in a new partner? Can someone sell their interest or be removed for misconduct? Again, you don't need to memorize every possible issue. The big question is this: does the agreement give the business a way to keep operating when the people disagree? Because "we'll figure it out" is not a deadlock provision. It's a future lawsuit wearing casual clothes. And then comes winding up. The part nobody wants to talk about and maybe the most important part of all. How does someone exit? What triggers a buyout? Death, disability, divorce, retirement, deadlock, misconduct, or just someone deciding that they want out? And once a trigger happens, what's the price? How does it get paid? Cash up front, installments, a promissory note? What happens to the company name, the assets, the clients, the real estate, the equipment, the guarantees, the restrictive covenants? This is why the buy-sell agreement is one of the highest leverage documents in any partnership. A buy-sell agreement answers one question: how do we separate without destroying everything? A good buy-sell agreement is not planning for failure. It's planning for a clean separation before emotions make the separation expensive. And that's really the point of this whole section. The agreement isn't just about how you start, it's about how you survive the change. Now, let's talk about the most human part of all of this, because a partnership is not sealed off from real life. Your partner may get married, they may get divorced, they may die or become disabled. They may have heirs, creditors, a spouse with legal rights. And if your agreement doesn't deal with those possibilities, then outside life events can walk right into your business. Let's go back to Marcus and Daniel one more time. Suppose Daniel dies. What happens to his 50%? Does it go to his spouse, his children, his estate? Does Marcus suddenly find himself running the company with Daniel's widow as his new partner? What if she doesn't know the business? What if she needs distributions or wants to sell, or starts questioning Marcus's salary? Notice, nobody has to be a bad person for this to become a serious problem. The family may genuinely need the money. Marcus may genuinely need control. The business may genuinely need stability. All three of those interests are legitimate, and all three can collide. A good agreement plans for this. It might create an automatic buyout on death and use life insurance to fund it. It might give heirs economic rights, but not management rights. It might prevent someone from accidentally inheriting control of a business they were never meant to run. The same thing applies to divorce. A partner's divorce can pull the value of the business into a completely separate dispute. Financial records, ownership distributions, compensation valuation, all of it can end up as part of the conversation. The details depend on the law, the documents, and the facts, but the risk is simple. One partner's personal life can create business consequences for everyone. And marriage matters too. Estate plans, prenuptial agreements, spousal consents, ownership restrictions. None of these should contradict the partnership agreement. Because the worst version of this story goes like this. A partnership agreement says one thing. The estate plan says another. The divorce court is looking at something else entirely. And now the business is stuck in the middle of all three. Outside life events will reach into the business unless the agreement builds a wall. Death, divorce, and marriage are not side issues. They can become ownership issues. That's why mature partners talk about uncomfortable things early, not because they're cold, but because they're responsible. Let me give you a handful of mistakes to avoid, and I see these constantly. The first mistake is confusing trust with structure. Trust is personal. Partnership is legal, financial, and operational. You can trust someone completely and still need clear documents. In fact, the closer the relationship, the more important the structure becomes. Family and friends don't need less clarity, they need more. The second mistake is assuming 50-50 means fair. We've covered this, but it bears repeating. Equal ownership can hide unequal work, unequal risk, unequal control, and unequal expectations. If one partner puts in money and the other puts in labor, define it. The third mistake is waiting until there's money on the table to define the rules. Once the business becomes valuable, every vague conversation becomes expensive. Because people remember conversations differently when money is involved. That's just human nature. The fourth mistake is assuming you can simply walk away. Ownership, debt, leases, contracts, guarantees, employees, taxes, pending obligations, these things can keep you tied to a business long after the relationship feels over. And the fifth mistake is using generic documents blindly. A template doesn't know your business. It doesn't know who's putting in the money. It doesn't know who's working 70 hours a week, who's guaranteeing the debt, or who's married. It doesn't know whether the business owns land, has investors, or depends on one key person. A template might be a starting point, but don't confuse having a document with having the right structure. So what should you actually do? Let's walk through it. First, define the partnership before the business gets busy. Once operations start moving, the urgent will always defeat the important. Second, put rights, roles, and responsibilities in writing. Who owns what, who does what, who controls what, who's responsible for what, who gets paid, who contributes capital, who signs the debt. Third, separate ownership from control. Someone can own part of a business without managing every decision, and someone can manage the business without owning most of it. The agreement should make that distinction explicit. Fourth, decide how major decisions get made. Borrowing money, selling assets, signing long-term leases, taking on investors, changing the direction of the business, approving large expenses, selling the company itself. Those decisions need a defined process. Fifth, plan the exit before anybody wants out. Decide the triggers, the valuation method, the payment terms, and the transfer restrictions. Decide what happens to the guarantees, the assets, the clients, and the company name. Sixth, talk about money early. Salary, distributions, reimbursements, capital contributions, loans, taxes, and guarantees. None of it should be vague. And honestly, if you can't talk about money at the beginning, you may not be ready to be partners at all. Seventh, treat family and friends with more structure, not less. Don't say we don't need documents because we're family. Say because we're family, we need to protect this relationship with clarity. That's the mindset shift. And finally, get counsel before you sign, before you contribute money, before you take on debt, before you bring in outside capital. It's almost always cheaper to structure things correctly at the beginning than to fix them after the dispute. And sometimes you can't fully fix it later. Sometimes all you can do is manage the damage. Let's bring all this back to the main idea. A partnership is a contract you write by imagining the future you hope never comes. That doesn't mean you expect betrayal. It doesn't mean you're suspicious. It means you respect the venture enough to protect it. You respect the relationship enough to avoid unnecessary conflict. You respect the money enough to define the economics. You respect the work enough to define the responsibilities. And the business, you respect that enough to give it rules before pressure arises. So before you enter a partnership, ask the three questions. How do we run it? Which means rights, roles, responsibilities, authority, money, control, books, decisions, and operations. How do we change it? That's new partners, new capital, amended terms, shifting contributions, outside investors, and changed expectations. And how do we end it? That means exit, death, divorce, disability, deadlock, dissolution, buyout, valuation, payment, assets, clients, and obligations. If the agreement can't answer those questions, the partnership may not be ready. Not because the people are bad and not because the idea is bad, but because the structure is incomplete. And incomplete structures fail under pressure. Think about Marcus and Daniel one last time. Their problem was never that they were brothers. It wasn't that one brought money and the other brought labor. That arrangement works all the time. Their problem was that they never translated the relationship into rules. They never sat down and said, Daniel, here's what your money means. Marcus, here's what your labor means. Here's who controls daily operations, and here's who approves major decisions. Here's how Marcus gets paid, and here's how Daniel gets distributions. Here's how we value the business, here's how one of us exits, and here's what happens if one of us dies, divorces, or can't continue. Had they done that early, the business might have survived. And even if the business didn't survive, the relationship might have survived. That's really the point. A good agreement can't guarantee success, but it can reduce confusion, reduce emotional decision-making, and create a path forward when the relationship changes. Because make no mistake, pressure is coming. Growth is pressure, debt is pressure, success is pressure, and so is failure. A new investor is pressure, a spouse is pressure, a death is pressure. Even disagreements are pressure. The question was never whether pressure would come. The question is whether your partnership was built to carry it. A partnership is not tested when everyone is excited. It's tested when money, pressure, and disagreement enter the room. So build the agreement for that room, not just the launch party. If you're thinking about entering a partnership, here's what I want you to take with you. Number one, you always have a partnership agreement, either the one you wrote or the default one the law supplies. Number two, trust is not a substitute for clarity. Trust may start the relationship, but structure is what protects it. 3, don't assume 50-50 means fair. Equal ownership can hide unequal work, unequal risk, unequal control, and unequal expectations. And number 4, use the what if lens. What if someone wants out or dies or gets divorced or stops working? What if we can't agree? Number 5, plan the exit before anyone wants to leave. A buy-sell agreement may be one of the most important documents you ever create. Number 6, talk about money early. Salary, distributions, capital contributions, debt, guarantees, and reimbursements should never be vague. Number 7, family and friends need more structure, not less. The closer the relationship, the more important it is to protect it. And finally, before you say yes to any partnership, ask 3 questions. How do we run it? How do we change it? And how do we end it? And that's episode 2 of Law, Land, and Capital. If this was helpful, do me a favor, like, follow, and subscribe. And share it with someone who's thinking about going into business with a partner, a friend, a family member, or an investor. And if you need a consultation or a referral, call the Titus Law Firm. You'll also find the link in the description. Next episode, we're talking about why contracts are not paperwork, they're battle plans. Because a contract isn't just something you sign after the deal is done. It's how you decide what happens when the deal gets tested. One more reminder, this episode is general education and commentary, not legal advice. Every situation is fact specific, so if you need advice about your situation, speak with a lawyer licensed in your jurisdiction. I'm Eddison Titus, and this is Law, Land, and Capital. And remember, own the structure before the structure owns you.